Alrighty, looks like we are live or about to be live. I'm George Simons. I'm one of the co-founders of SoloSuit, and as you know, we help people respond to debt lawsuits and also get their debt lawsuits fully resolved by settling them. Looks like audio and visuals good to go. If there's any problems, let me know in the chat. Alright, so I'm going to go over some of the basics on how to respond to your debt lawsuit today. Reserve most of the time for a Q&A at the end. If you have a question, put it into the chat. There's a lot of people on, so make sure you get those questions in, and then I'll be responding to some of those here verbally, and we also have Hannah on the line who will be responding via text. So between the two of us, hopefully we get all the questions answered. Before we get going, just a disclaimer, I'm not an attorney. I'm not your attorney. SoloSuit's not a law firm. We don't represent you in these cases. This is not legal advice. This is just a webinar. Okay? So I say those things just because of regulations on the practice of law. All right. So real quick, some of the basics. Let's take a look here. Alrighty, so when you get sued for a debt, you get a summons and a complaint in the mail sometimes. Sometimes someone hands them to you. Sometimes people are like, hey, I got a pizza for you. Wapa. Lawsuit, actually. Sorry about that. That's what happens sometimes, or sometimes they hop over your backyard fence. Heard of that happening? Run up and like hand you a lawsuit. So you get served somehow the complaint and summons. And then what happens next is you need to respond with an answer document. That's a capital A answer document. It's not just like some regular little love note they write on a piece of paper and then fold it up and send it into the court. Nope, it has to be a properly formatted legal document responding to the complaint and the summons. All right, so that's what most people use our SoloSuit like document products. Okay, so you can use us to respond to the answer document. You can use this to respond to the summons and complaint with our answer document. You can generate that on our website. All right, and then just just to show you, might as well show you what that looks like. Picture's worth 1,000 words, as they say. So, just a little idea on what that looks like. You come onto our website, solosuit.com, and then you just click reply to a debt lawsuit. Click the get started button. You might want to note we have 4.8 star rating out of 521 Google reviews. You can even click on some of those, and you can come down and click on them and read some happy customer reviews if you'd like to. We got Diana Rodriguez. She said, I hope all goes well. I have no money. And so far, there's been no pressure from this company to purchase the 3 or 4 packets they offer. But maybe later I can scrape a few pennies together. I'm disabled and I have no income due to loss. So, sounds like she was using our free service, which everyone's welcome to use. You can use our service that's currently free. Price is always subject to change, but you can use it to generate a document. Then you have to file it on your own. Only about 20% of people ever actually file it on their own. So we do recommend using one of our paid services if you actually want to win your case. Let's see. Mike Armstrong said they do awesome work. Choose them to help you. Erica said absolutely great service and very user-friendly. Then we have Johnny Valdez. Thank you. I took all the recommended steps all the way to the wire. A $4,500 credit lawsuit was settled in front of the judge for $1,400. That's big winnings for Johnny. Looks like he saved himself about $3,000. That's fantastic. All right, so those are some happy reviews. Just click the get started button here, and then you will have to make an account. It's very simple. You just give us an email address and a password. We do that so we can save your information on the answer. And then you tell us like what state you're in. Let's imagine that we're all in Hawaii for the moment. You'll choose a package. This is what the packages are right now. Again, pricing changes from time to time. The premium package is the best deal. Not just saying that, but usually an attorney costs about $3,000 to get started on a litigation case. In this case, we respond to the lawsuit and have an attorney review it, make sure it's good to go for just $247, plus filing fees that might apply depending on what state you are in that are charged by the court. All right, so you just kind of walk through the process, you answer a few questions, and then you kind of go from there. All right, you want to make sure you have the summons and complaint ready, and you just answer some questions. It's pretty straightforward. All right, so that's the document. That's the answer product to respond to the lawsuit. What a lot of people do is they answer the lawsuit and then they come on to back to our website and then they click a settle a debt lawsuit button. You can also get to it if you finish your answer. You come out to your dashboard and then you can just click the learn more button and click get started. And then same idea, we ask you some of the same questions. You're just going to type in some basic info, and we'll ask you to essentially make like an initial offer, like tell us what you want to settle for, and then we'll initiate the settlement with the collector for you. So that's how it works. All right. So most people use this to file an answer, and then most people want to settle because usually that's the best outcome, getting thousands of dollars knocked off your debt, and also getting it nice and tidily resolved so that the collector's not coming after you anymore. Right? And you can do that with Solo Settle. All right, and then what a lot of people are using is, well, at the moment we're calling Solo Settle Premium. Working on a new name for that actually. Might call it Solo Settle Assist. We'll see. Name is pending. And then basically what this one is so you make an offer. You can make an initial offer with Solo Settle. Where we're seeing the best results is with Solo Settle Premium, where we activate. Basically, you're opting to activate a law firm for you, and then that law firm will actively settle the debt for you, and they do a great job. So you'll interact directly with them and get that thing wrapped up. It's awesome. We're seeing a lot of great results. Some results that I have on top of my mind is, we saved one woman fairly recently over $10,000. Right? She came to us with about a $25,000 debt. After settlement and commission, she, I believe, ended up saving around $11,000. All right, so she settled it for around 50% of the debt. So that's a big win. So if you want to get results like that, definitely recommend Solo Settle Premium. You don't want to wait too long. You don't want to wait till it's too late to settle. You want to get started with that ASAP. All right, so let's see. Let's dive into the questions. And sorry if you're hearing a baby crying. I'm at home. We work from home in Solo Suit. So there you go. It's just real life. But, got a happy family that cries sometimes. As families do. All right. So let's see. We got Papa Docs. I have a question. What is the difference between the premium package and the standard? They look very similar. Sure. So one thing, I want to make sure you don't confuse the Solo Settle Premium package with the Solo Suit Dead Answer Premium. Right? It's a little bit of a long name. That's how we think about these, right? So you got the Dead Answer Premium. And think you're talking about the dead answer premium. We also have the standard. So why don't we just go ahead and take a look at those options again real quick. All right, so we have the premium option here. You have the standard over here. So with the standard, we file for you. It takes 1 to 8 days. Okay, so again, if the customer is really responsive, if everything's packaged up nicely, if it's in a court that e-files, that accepts e-filing, then we can get it done in 1 day. If not, if you're not responsive to us, if you don't upload your summons and complaint properly, if you don't upload the fee waiver properly, then it might take longer. It could take 8 days. So that's just a note there. For the standard, we file. So usually, in most cases, we actually file by USPS mail because that's like the one standard way to file court documents across the U.S. If there's a good e-filing system, we will e-file it for you in the court. On standard, we usually mail it by first class certified mail. That's 3 to 5 days. Most of the time, it's going to get there in 3 days. So that's the thing on standard. And then for the premium, you'll see we also file the document for you. It's 1 to 6 days. That's because these ones we file by USPS priority mail, 2 to 3 day mail. Usually gets there in 2 days. Sometimes we do FedEx overnight on select cases. And the main thing here is attorney review. Might be a little bit hard to notice, but down here you have the attorney review. That's the main thing that people are paying for. So we'll have an attorney, a contracted attorney that reviews your document. Again, we don't have an attorney-client relationship with you in this situation. The attorney is just reviewing the document, and they'll make sure that things are good to go on the document. And we'll just basically make sure that you have entered information appropriately onto the site, right, and made like appropriate selections on the site. All right, so that's the main idea. The attorney review does rather frequently check issues that if the person wasn't paying for the premium package, the customer would have pretty much automatically lost their case without that attorney review. All right, so that's the difference between those packages. All right, Josh Green, for solo settle, I see 19% commission on the total debt. So if you settle the debt for 81%, does that mean I'm still paying the total debt amount? Yes, good question. That is what it means. What we oftentimes see with people, a lot of people, sometimes people do opt and accept settling for a balance in full. And usually why they do that is, let's say you're being sued for $1,000 debt. Okay. Then what a lot of people miss, what we're trying to work into our educational materials, make it more clear, is that the costs of that lawsuit are much higher than just the $1,000 that you're being sued for, right? So if you don't settle, you just try to go through the lawsuit and you lose, which you might, it's pretty likely that you'll lose if you don't, if you actually owe the debt to some degree and you don't settle. The actual cost of the lawsuit are probably going to be an additional 70%, right? So in this case, the actual cost of the lawsuit would come out to $1,700. I think some attorneys would even estimate it's more like 1.5x, so like 150%. And what that includes is statutory interest, which is oftentimes around 10%, depending on your state. So if you're being sued for Discover credit card debt, most of the time you're going to have that interest from the card, and then once you lose, another 10% interest will be added on top of that. Pretty crazy. That cost will escalate very quickly. So then you have statutory interest, then you have plaintiff's attorney's fees. And then you have like just the pain of garnishment and a bunch of other stuff, right? Like having to hire an attorney to represent yourself if you wanted to go a different route. So those are all things that are added on top of this lawsuit to estimate the cost. So then, yeah, we take a 19% commission, which is only due if the debt actually settles. And there you go. Most of the time, average settlement right now is 71%. The range is quite broad. Sometimes people settle for 20%. Sometimes people choose to settle for a balance in full. That's a real thing. We are looking into, all of that said, we are looking into a way to make the fee dynamic. So like if savings is like less than, if the debt settles for more than 80%, our fee would decrease. So there's always savings of some sort. But that is the situation. And most of the time people are saving a significant amount of money. Jacob, I never understand the number of paragraphs in which and how many to answer. Formats on my summons are diff compared to your example. Okay, so yeah, we have an example with like a summons and complaint, right, where it looks kind of like this, where it's like the court, and then it's like this stuff, and like the case number, and then a bunch of numbered paragraphs, right? Not all complaints look like that. You might be in Texas. Sometimes a petition in Texas looks more like this, where it's like a bunch of different boxes. Right? And like you'll notice those little boxes have a bunch of numbers in it. It's kind of more like a tax form or something. The main idea though is, you just want to respond to however many like separate allegations there are in the complaint. If you have doubts, this is one of the main reasons people go for the premium package, is to make sure an attorney reviews the document and make sure they're appropriately responding to all of the paragraphs in the complaint. All right, so that's a big reason why people go for that. PTK, what happens when you come to an agreement with a payment due date but still file an answer? Do I still make the payment on the due date or wait for the agreement in writing? I'm not sure I'm totally following either. Sounds like you filed an answer, but before you filed the answer, you had a settlement agreement, like a verbal settlement. Basically, if you get a verbal settlement and you haven't filed an answer, you definitely want to file the answer first. You definitely want to file the answer still. As no, so you get the summons and complaint, file an answer, and then you settle. So filing an answer protects you against default judgment. It protects you against dirty tricks. Like if you don't file an answer, there's not much stopping the collector from settling with you, quote unquote, like settling, quote unquote, and then filing default judgment against you behind your back because you never filed an answer. You didn't protect your butt. Okay, so you want to make sure you file an answer, and then you want to make sure you get the settlement agreement in writing. You get the settlement agreement in writing before making a payment. It's up to you what you do, of course, but if it were me, I would make sure I had a settlement agreement, probably one that is signed by both parties, and that's what we do with Solo Settle. Right? That's one of the reasons why to go with this, is to make sure all the paperwork of the settlement is done properly. Make sure you aren't getting secretly shafted by somebody. All right. Isaiah. Nope. We're on to Haley. All right. I filed an answer to a debt lawsuit and now have mandated mediation next Thursday. I've had debt removed from my credit report already. Okay. If you had that debt removed from your credit report, that's pretty interesting. Good job. I don't think that's very commonly successful to get a debt that you're being sued over removed from your credit report, but that's great. If it's a fraudulent debt and you don't owe the debt, then for me, I'd go to mediation and just make that really clear and not agree to pay anything on the debt. Mandated mediation's pretty nice experience usually. So you show up at the courthouse or virtual. It'll be you and the plaintiff or the attorney for the plaintiff, and then there'll be a third-party mediator, which is a person, usually a lawyer, hired by the court that will try to figure out an agreement between the two of you. All right. So remember, if this thing goes to trial, the burden of proof is on the collector. So that means they'll have to prove that you actually owe the debt. It's not up to you to prove that you don't owe the debt. It's up to them to prove that you owe the debt. So that's how people will win these cases oftentimes. Is either one, they don't owe the debt, or two, the collector can't prove that they owe the debt. And that'll be an important thing to keep in mind when dealing with the mediator. All right, so you don't need to concede to anything. You certainly want to know if the collector can actually prove that you owe the debt if you do. Isaiah. I emailed an offer to the law firm using SoloSuit service, not knowing how much SoloSuit would charge. I don't have enough money to cover the lawsuit and the charges. Okay. Isaiah, I guess my main question in this case is, did it settle already? Did the collector accept the settlement? And then usually right now, if it's a recent settlement, then you have 30 days to make the payment. And then just noting, like, we try to be as transparent and upfront as possible with our charges, right? We emphasize that it's 19% of the total amount of the lawsuit on our landing page, and then we also, I think, show that amount to users or to customers twice before they click the submit offer button. Right? We show the breakdown of all the costs on the website, and so we do that math for you. If you want to check it out, you can just go through the flow and take a look. I'm not sure what to tell you in this situation. We are looking into like a feature on the product where people will be able to pay SoloSuit commission over time. But right now, it's not an option. Perhaps there's someone you can turn to. A lot of times, our customers do turn to someone to get some kind of a personal loan established. That would allow them to make that payment and get things settled. And again, if you haven't, nothing's really formalized on settlement until you sign the settlement agreement. If a settlement agreement is signed, once someone signs that, they definitely want to make sure that they make the payment. On most settlement agreements, if you don't make the settlement payment, then you'll lose your case, and it basically has the equivalent effect of a default. Okay, Florence, what's next after responding to the debt lawsuit? Yep. So next up is settling, right? So you want to make an offer to settle, hopefully using SoloSettle Premium, because that does get the best results. Drew, I just got summary judgment recently on a debt lawsuit. Is there any way to use your service to dismiss the judgment/lawsuit? On a summary judgment, usually not. Summary judgment means that they filed the summons complaint, you filed the answer, and then there was a summary judgment. If there was a default judgment, that usually happens when you don't file an answer. Then, yeah, you can file. If there's a default judgment, then you can file a motion to set aside the judgment. An MSA is what we call it. You can email us for a motion to set aside judgment, and then you can file that along with your answer. You can always try that with a motion for summary judgment, but it's unlikely to work. All right. Isaiah, I filed an answer, but don't know what to do about the offer. I think Hannah got to that here. I'm going to skip ahead a little bit on the questions, just for the sake of time. We have about 2 minutes left on the webinar. If you can believe it, time flies when you're having fun. You know what I mean? All right. Let's see. Isaiah, should I call the law firm to settle? Yeah, if you want to. Yeah, for settling. So if you don't want to use SoloSettle, you can you can call directly. A couple things to keep in mind. One, you will settle with the law firm, not the plaintiff. So if you're being sued by Discover, you don't call Discover. You call Discover's law firm in most cases, unless it's like an internal attorney, in which case you would. But main thing, you want to call the lawyer at this point. And then, yeah, you can call. You can also do an email. You find people are better at negotiating, not in real time over email, but if you want to negotiate in real time over the phone, you can do that. The collectors are professional negotiators, so they're going to be pretty tough to work with. But that said, most collectors are set up to take calls on the phone instead of by email. Judy, do you charge extra to negotiate a monthly payment? No, we don't. We don't charge extra. It's just 19% no matter what. You can only get a monthly payment on the premium service right now. So if you do the Solo Settle Premium, we can happy to do a monthly payment plan for you. Okay. Cobb, what is the proper course of action after a debt validation letter? Solo settlement or motion to compel arbitration? And when should I do it? Let's assume the court date is March 10th. Okay. So let's take a look here. So the debt validation letter, we're going to call it the DVL here. Debt validation letter is meant to be filed before, it's meant to be sent before summons and complaint. All right, so if you get a collections letter, just like it could be from a law firm or a collection agency, might send you a letter saying, hey, you owe us this debt. We got to collect on it. Then you can say, no, I don't. You got to prove that I owe the debt. And you do that by sending them the DVL. And then if they might respond by validating the debt. So let's say they validate it. They also might just cease and desist and be like, hey, I can't prove that this person owes the debt, because they don't. I was actually just trying to collect money from someone who doesn't owe money. But then if they do validate it, then the collections might continue, and then what might happen is the collector might file a lawsuit. Okay, and then at that point in time, you want to respond with an answer document and then do the settlement. We don't help with settlement before the lawsuit up in that time. You're welcome to settle on your own. All right, so ideally, if you do owe part of the debt, you'll send them a debt validation letter, and then you'll try to settle it with them, or you might wait until they validate the debt and then try to settle if they do validate it. All right, folks, that's all we have time for today. I think Hannah responded to pretty much everybody on text as well. So that's the general idea. Very good to see everybody. Again, Team Solo Suit is rooting for you. We are here for you. We hope that all of you guys win your cases and that you get the justice that you deserve. All right. Good to see you. Take care.